You're watching this other guy's hearing. It's a non-recorded hearing, theoretically, right?
It was not. They had a court reporter in there. We didn't pay that much attention to it, but this was supposed to be an informal hearing. But it was not
informal hearing, but it's not your hearing.
That's not my hearing.
You're just there with several other people as court watchers to see the corruption at work.
Correct.
Is that correct?
Right. We were. Some people might call us auditors of the court. You know, we're just.
Ed Brown would call them constitutional rangers. That's
okay.
Ed Brown, and he's still in federal prison. Charles Weller, judge, a very corrupt judge from everybody I talked to from Reno says he's corrupt, including the attorneys.
Going back to the corruption in the courts. For several months before our trial, we submitted a total of 40-some motions, and they were good motions. Every motion was denied by Judge McAuliffe, many of which were denied with no objection being filed by the prosecutor. Something's wrong there.
Really? No. Want to give you federal grants? Don't you understand why they make this agreement? They're called a mutual understanding agreement.
Come on, they're getting armored personnel carriers, they're getting
all the toys,
they're getting all these toys, they're getting guns, they're all militarized now in this country. All the police are now militarized. They're an army. Why do you think they're an army? Because they take our National Guard and our army and put them overseas in all these countries where we don't have any business being to begin with, and they're taking our police and turning them into a military force all over the country to go against the people, which is exactly what they've been doing for the past 10, 12, 15 years. And
so we ought to pull our troops out of Iraq right now.
What?
We ought to pull the troops out right now.
We should never put them in there in the first place.
Yeah. The National Guard should have been here.
The first war, I could see, okay, you did something you thought was right, okay, oops, made a mistake, we got out. So what did this idiot, George Bush Jr. do? Go right back in and do the same thing again. Well, my daddy did it, so I have to go do it too, duh. And go and murder a whole bunch of people.
Am I right in guessing you didn't vote for George Bush?
I don't vote. There's nobody to vote for. There is no vote.
You never heard of anybody you could vote for, not Ted and Credo?
There is no vote since 1979 in this country. Doesn't exist. Look, read Vote Scam and see the truth.
Well, Ron Paul's running from Texas, and he wants
He's never going to make it.
Well,
never going to make it. He's going to do the same. They're going to do the same thing with Ron Paul, even if he was getting close and popular, that they did with Ross Perot back in the early '90s in the Bush election.
I remember that election.
Okay, we're going to do the same thing now. See, we're so dumb. We are really such a dumb nation. They keep doing it to us over and over again, the same thing, and we keep falling for it every single time. When are we going to remember what they've already done this to us and not fall for it again? Ron Paul would, hands down, become our next president if it was a popular vote. But it isn't a popular vote. It's electoral college vote, isn't it?
That's right.
So what is our vote worth? Nothing.
Yeah, and the
so why are we
machines.
voting?
Yeah.
There is no reason to vote. And besides that, if you're voting, you're saying, well, we endorse your corrupt way that you operate here in the voting system in this country and the form of government.
So what should the people do? Should we arm ourselves and literally go down and throw our legislators out, arrest us in the state Supreme Court?
Not yet. Arm yourself. Absolutely. Protect yourself. Okay? And then turn your back on all administrative government from your town. Don't do any more zoning, building permits.
Don't bother with them.
No more don't bother. Just ignore them. Like they don't even exist. Don't pay any more taxes into them. Nothing. Let it drop. If you want your roads taken care of, subcontract it out privately. Let some guy go plow the roads and maintain the highways. We don't need them to do that for us. We can run bus our kids to our own private schools. Public school is nothing but communism is what they're teaching in this, in the public school. So we don't need that. So we need better schools. So we don't pay any of those taxes. Turn your back on them and walk away. My own peers all around me. Grow up. You don't need someone else to do this for you. Do it yourself. Take care of your homeschool. Homeschool them. And if you can't homeschool them, then hire a babysitter that's a good teacher or a nanny for about 20 kids. Put up a nice little hall, and like this house here would be a perfect place for about 20 or 30 kids in here. Okay? And we'll teach them right here. We don't need the public school system to teach our United Nations agenda.
We should not have a public school system.
Public school system is a dead issue.
Public schools are state schools.
Please do. Ready?
Yeah, I'm ready.
This is American Jurisprudence, 2nd edition on the state and federal conflicts of laws. This one here is on constitutional law. Conflicts of law, constitutional law, okay? 1 through 359. And here we're going to read 256. Generally, it says. Now the title of this section is effect of totally or partially unconstitutional statutes. Total unconstitutionality. Okay? Generally. Generally means everybody and everything. Here we go. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such a statute leaves the question that it purports to settle, just as it would be had the statute not been enacted. An attorney, by the way, not attorney or attorney, attorney, A-T-T-O-R-N-E-Y, is how you pronounce it correctly. Now, if you look at the word attorn, it's basically take from one person and give it to another.
Which is what they do.
That's what they do.
That's what they do.
That's what attorneys do. That's why nobody likes it.
Well, I don't give legal advice, but my First Amendment opinion is...
You should.
My First Amendment opinion is that when you hire an attorney, you've already lost.
Exactly. Listen, these judges, for the most part, they know procedure and due process. They know procedure. They don't know due process anymore. Most of your lawyers, and all judges are lawyers, they understand order taking. That's what they're trained to do in law school. Take orders. Because there's a little book up here, and they open it up here, and they have studied this little book here, and they write in here, okay, so-and-so did this, the book allow, okay, let's give it to the judge. And the same process in every case. It's just like a rubber stamp, over and over again. And if you challenge, say, hey, lawyer, I want to hire you to be, not to represent me, because it's not represent, it's represent. And when you say represent, what does that mean? That means you're going to represent me as what? I'm already present. I'm already here. You want to have me represent myself as something else? We found out. They want you to represent yourself as a fiction.
As your straw man.
As your straw man. All uppercase letters that you get from the IRS, or you get from the government, or you get from the state. Well, their names are in upper lowercase. Yours is in all uppercase. Now, why is that? You mean the computer cannot tell the difference? Oh, so yeah, I can tell the difference. Believe me, I can. We just turned down, both of us turned down Social Security that we're entitled to. No, we thought that was our retirement money. We're not entitled to it. We had a right to that money because we invested it for our retirement money into that rather than put it on the stock market.
I'm thinking of another man in Camas, Utah. I interviewed the family after. In fact, I got to know the family quite well. The Singer family. Mr. Singer was raised under Nazi Germany. He had very strong anti-government feelings. And they couldn't get him because he stayed on his 5 acres. So he went to get the mail one day and they chased him through the snow and shot him in the back in front of his family. He had a gun with him, but he didn't shoot back. He was just trying to run back with his mail and his gun. Should he have turned and fired directly at those sheriff's deputies on snowmobiles?
Should he have?
Yeah.
I would have. You fire at me, I'm going to turn around. I'm going to return fire. Matter of fact, I wouldn't. Did he have a handgun?
I believe his wife told me, Vicky told me he had a shotgun.
Oh, I would have waited until he got close enough. I'd have killed him.
But he was running through waist deep snow, holding his mail in one hand, the rifle in the other hand. And
waist deep snow, go under.
Yeah.
Let him come up to the track. As soon as they get close enough, just come up.
They shot him in the back. And his whole family did not do well after that.
That's what they are. They're back shooters. They're scum. They're pond scum. They're cowards.
They shot Sammy Weaver, 14-year-old Sammy Weaver in the back and killed him.
They shot one of their own guys in the same thing at Weaver's house. They shot one of their own agents right there. None of the Weaver family shot that agent. Their own guy shot that agent.
Well, that's what happened with Singer. They shot the police shot the dog handler, and they refused to let the bullet be identified by the defense. They lost the bullet because it was
Because
proved
they're
that Singers didn't fire.
cowards. They're seditionists. They're traitors. Come on, guys.
So it's time for America to have a
Time for
revolution.
America to get up, pull up bootstraps
Yep.
up here, and pay attention to what your public servants are doing.
Arm yourselves, it's coming down.
Arm ourselves. What
Yeah.
if we could get a third continental Congress? How would we choose the delegates from the different states? If we decided we weren't going to go to D.C., we were going to have a third continental Congress, say in Lincoln, Nebraska.
We
And
want, first it goes,
How would we choose the delegates?
first you gotta start in each state. You choose the delegates in each state, each county. The county votes who's gonna go to the Continental Congress, the convention, the Continental Congress. That's all.
That's what we should do.
That's what we are doing, we're working on it now.
You are working on it.
Oh yeah, we're not waiting for
The
this.
Constitution Rangers are working on it, or a
Yes,
different?
with others, yes.
Okay.
Right now, UAIC, you know, your Rangers are, with other people, other groups, yes, we're working on it now. We're pulling people together now to do this. I think there are 4 states already getting involved. Chicago, there are Illinois, Michigan, I think Ohio is, and of course here in New Hampshire. I talked to Maine, I talked to Massachusetts, and they have the interest as well too to get started, so it'll go pretty quick. It won't take that long.
Well, I want to thank you for this interview. Is there anything else you wanted to say to tell people in Britain, Germany, anywhere in America?
Yes.
This is a global problem, it's not just in America.
This is a Freemason global problem, ladies and gentlemen. Tony Blair and the rest of them, even to the Queen, it's all Freemasonry in England. Pay attention. They've done it before to you. They've been doing it to us for hundreds of years. It's time now that we went after them and brought them to justice big time. They know we're coming. That's why they're preparing for this conflict. And it is going to be a conflict, and it will be global. So we tell the other side, in final shots, I always say to them, behave yourselves. You have us surrounded, but you have nowhere to hide. You can do me, but my friends can do you.
Well, thank you. Thank you, Ed and Elaine Brown, for letting me into your house in this beautiful setting in New Hampshire. People, there it is. You can sit and do nothing, or you could do something. You can share this information with somebody else. Is the government out of control? I think so. This is William Wagner for On Second Thoughts from Elaine and Ed Brown's house in New Hampshire. So then you go out to take a leak in the court bathroom, you come back, you sit down, and the bailiffs do what?
About 15 minutes later, the person whose case we were going to be seeing stood up. He was turning around to go use the restroom, he later told me. But when he stood up and started turning away from the court, he was in the gallery as everybody else was, but the judge asked him to stop and turn around and come back through into the bar area and sit in the jury box. And he started questioning that right away because we, as everybody in the courtroom there, had seen a guy who was owed the court money, and she had sent him to the jury box when he could not pay his fine or whatever it was. She sent him to the jury box, and we later saw him taken out in handcuffs and placed under arrest. So when this guy who was going to go use the restroom stood up to walk away from the court, and she instructed him to go into the jury box, he started questioning why right away. And as soon as he did, the bailiff started yelling at him. And apparently, something that I didn't realize to the bailiff, and said something in private, you know. So this is only what I was told.
So what happened to you?
So this guy is protesting on his way over to the jury box, questioning the judge as to why she was doing what she's doing, and the bailiffs are screaming at him to get in the jury box, shut up, and sit down. And so when he got into the jury box, there was this, he was sitting down, and then he was standing up to say something else. Well, why am I in here? And then they'd tell him to sit down, and then
okay,
he'd stand
what
up.
happened to you?
What happened to me was that I was taking notes on what I was seeing, and the next thing I got a nudge like this from the court watcher that was sitting next to me, a woman, and she said, and I looked up and I'm seeing this physically, and I'm hearing stand up like that.
He's pointing at you and got his other hand on the gun.
Right, or near the gun.
Near the gun.
He's like this, and he's saying, and he's yelling at me, saying, "Stand up," like that. So I stood up, and as I stood up, and you know, my whole awareness is just like, what the hell's going on here? And then I heard a shrieking, "Sit down!" And apparently it was the judge telling the guy in the jury box to sit down, but I took the hint and I sat down. And so then I pick up my notepad and I'm going back to what I was doing before. And so then I heard this loud commotion and more screaming for stand up. And when I looked up again, he has his hand on his gun and he's like this again. And he's about 2 rows in front,
Right.
leaning over the rail. So I stood up, while I was there, I think I said, as I look at transcripts, because I do have some transcripts, and shouldn't have said that, but that they were furnished about 1.5 years later. These transcripts say that I had said I did stand up, but I stood up anyway, and when I did, apparently some other witness testimony that I have shows that the judge had asked me my name. I didn't hear it. I wasn't directing. I had no judge had no jurisdiction over me.
You were still in the gallery.
I was still in the gallery, and I wasn't paying attention to what was going on behind the bar. What I was looking at was this guy with his hand on his gun, and I wasn't paying attention to anything else. And about that time, there was other people, other police officers that were coming into the courtroom, and I'm just frozen, and I'm not moving. And so next thing I knew, there was an instruction for me to place my hands behind my back. The bailiffs or the police officers took me through the rest of the aisle and into a concrete room that was dark, that was adjacent to the courtroom. I mean, if you open the door, you could see the judge's place right there. It was right there at the courtroom. And so for an undetermined amount of time, I was sitting in there while they had the door mostly closed. And from the affidavits that I've got, what she did from that point forward is, as soon as they had put my hands behind my back, she said, she screamed out that she had a courtroom full of Moors and that she needed some extra help. And then she said, according to the transcripts that I said that I have, she said, and the next one is right there, you know. And then she started inquiring, and this guy, he got up, and as soon as he saw me being handcuffed, he was another court watcher, he got up and he just started heading for the door. And so what they said is, you, sir, you come back here, and they actually physically moved him back to his, they, you know, accosted him, put him back towards where he was sitting, and then he had to address the judge as the judge drilled him on who I was. And so based on that information, I can't say that she knew who I was at all. But
okay, was there any Moors in the courtroom at all? Did you notice or see even one Moor in her courtroom?
well, I can't identify what is a Moor, what is a Christian, what is a, you know, anybody else, but so I don't.
Well, how could she identify them then? If you can't, and you're sitting closer to them than she was, because she's up behind the bench, how could she identify Moors? Or was that just gobbledygook to put on the record to justify her abuse?
Well, and the way I read the transcript, it did look like that she was trying to justify after this whole thing was getting to a conclusion. But she did. And to answer your question, you can't. And in fact, she wrongly identified me as a Moor. For all purposes.
Okay, so now you're identified as a Moor. They take you out in handcuffs.
Correct.
They take you in a police vehicle to a county jail 6 counties away. Which county was that?
That was Midland County. So that is 6 counties away from Wayne County where this happened.
Do you have any idea why they took you 6 counties away?
I have no idea whatsoever. And in fact, the police, the report, I'll show you the...
How would they have jurisdiction to take you to another county?
None of this was done with jurisdiction. There was no jurisdiction.
There was no jurisdiction. So you had a total kangaroo court in full swing and people complying with the kangaroo nutcase judge. What was her name?
Her name was Karen Khalil.
Karen Khalil.
Khalil.
So you got this nutcase, Karen Khalil, running a kangaroo court, and nobody thought to arrest her on the spot?
Nobody arrested her, and that's the basis of my federal case right now, because it's called a state-created danger. Once that judge issued that order to those police officers had a choice. Knowing that I didn't do anything except sit there, that the bailiffs, the judges, the judge herself, the police officers that came into the room, none of them had any evidence whatsoever that I had done anything to disrupt this court or to be charged with what ended up being a contempt of court, criminal contempt of court charge.
So you end up spending 30 days. How did you get out? They just suddenly released you after 30 days?
It was without bond. This whole thing, it was, I ended up, they would not, because it was supposed to be a informal hearing, this court, now this is confidential, please. You already got it.
So then after you get out, after the 30 days, you discover they manufacture a case that allegedly took place, but in reality, you were never given notice to this case. There was no case number till after you put 30 days in Midland County Jail, and now you're out, and now they start manufacturing to cover up what they did to make it appear as if you had had a trial.
Well,
did I say that right?
Actually, that's incorrect, because this judgment of sentence right here, partially right in that there was no case. I had no case before the court. But this judgment order that was signed on that day that they took me to jail, signed by that judge, says that there is a case, and they assigned a case number that didn't exist before. They say this was a case of the people of the township of Redford versus David Scheid, and that the defendant was found guilty on June 8, 2012 of the crime as stated below, convicted by, it says that I had, it was one count, pled guilty for contempt of court. It says here that defendant was advised of right to counsel and appointed counsel.
And was there ever a time you were in Karen the witch judge, was there ever a time you were in a court and you pled guilty to anything?
Absolutely not. Absolutely not. With regard to this case here, that I was appointed counsel and knowingly, intelligently, and voluntarily waived that right. None of this is true. This is completely fraudulent.
Complete fabrication, just like the Michael Jackson evidence trial. Completely fabricated evidence that, when put to a jury test, did not stand up. So do you think you'll get justice in any part of this? When you're done with all this, do you think you will really get justice? That they will pay out on somebody's bond and you will collect money or get something for your 30 days wrongfully incarcerated? Because that's actually kidnapping. That's false imprisonment and kidnapping by somebody masquerading as a judge with jurisdiction authority. Do you think you will ever get, Mr. Scheid, justice?
The justice is going to come from the court of public opinion. It's not going to come from any court that we have, because I don't believe these courts, they call them court buildings, courtrooms, but we don't have courts running in place. We've got, in Wayne County anyway, I've got the evidence, we've got domestic terrorism and domestic...
So these are county terrorist torture chambers?
That's correct.
Star chamber proceedings?
That's correct.
Okay, you heard it from Mr. Scheid himself, right here at his home, someplace in Novi, Michigan. William Wagner here in Toledo, Ohio, where there are some gentlemen gathered who know things that maybe you ought to hear about. We're going to start today here in Toledo with Brian T. Michael. Brian, what do you got to tell me?
Hello, my name is Brian T. Michael. What I have to give to you today is that in Columbus, Ohio, in the court system, there is disability fraud involving guardianships. There is administrative abuses going on with judges. There are cover-ups with prosecutors on RICO. We found out that the dispatch ran a 5-part series, that the court was complicit, that they had specialized doctors that were unlicensed. Dr. John Gill Randall was an unlicensed psychiatrist going around rubber stamping people with Alzheimer's dementia in order to trigger guardianships, and the judges were steering contracts to their fellow magistrates. Now, we have Supreme Court documentation that says there had been a history of rubber stamping a former magistrate. His name was Brian Johnson, his pleadings. So what we understand is that people were also being human trafficked into nursing homes, and that one of my friends was lucky to get out of the nursing homes. Her name is Geraldine Stanson. They ran an expose on her. Her best friend, Kim Albert, died at the age of 55. She was a homeless person, and her guardian, who was also my mom's guardian, was Kevin Crane. Now, the law firm was Kincaid, Randall, and Crane in Upper Arlington, and the unlicensed psychiatrist was Dr. John Gill Randall. He was the unlicensed doctor, like I said, going around rubber stamping people with Alzheimer's dementia. One of my attorneys who filed a 60B, which is a fraud action, was David Belinkie. We found out that David Belinkie's wife was former chief legal counsel for the Ohio Department of Mental Health. So a lot of the corruption ran into families of the Bexley community and families in Upper Arlington. Now, we also know that this corruption was generational. That the sons and daughters of these people were taught, their parents taught their kids how to get these guardianships and these disabilities up and running. Now, we know some of the judges were complicit too. Judge Metcalf, former probate judge, his son was a broker. We know that they were steering contracts to Stephen Metcalf in order to launder people's money out of their estates. And so, like I said, we found out that one of the gentlemen who was an esquire by the name of Paul Corminick was charged with 11-count indictments. The prosecutor is Thomas Allen. He will be sentenced October the 20th in the year this year in 2015. They dropped the RICO charge, but we know that he's going to plead guilty to the other 10 indictments. My case is currently being...
What county was that in, if I can interrupt you, Brian?
Sure, this is in Franklin County, Ohio.
Franklin County, Ohio.
Franklin County, Ohio.
And who's being sentenced in October of this year?
His name is Paul Corminick. He had over 400 wards. He had 400 guardians that he was responsible for. And some of the things he was charged with was falsifying documentation, embezzlement of funeral funds from the indigent fund through the county, hiding assets. And the other attorney who's under investigation by the Discipline Council was a former magistrate by the name of Kevin Crane. He lives in Upper Arlington.
So both these guys were bar-carded people.
Bar-carded people, and they were just the tip of the iceberg.
And 400, he was getting, let me understand, he was getting paid for 400 people he was guardian for?
That's correct.
And then he was shipping them off to nursing homes?
Some of these people were in nursing homes, and they were being medicated with up to 10 or 11 psychotropic drugs, so they couldn't. Geraldine, one of my best friends, she's alive. She was able to get out of Regency Manor, one of the nursing homes on Allen Creek.
Regency Manor.
Regency Manor was the name of the nursing home.
On what street?
I believe it's on Allen Creek Road or Allen Creek Drive in Columbus.
In Columbus, Ohio.
Yeah, she was able to get out of there. A psychologist by the name of Dr. Weaver said she should not be under guardianship, that she could take care of herself and live on her own. But a lot of these people, they have their businesses taken from her. She had a $200,000 home up in Worthington that was taken from her. And they find out that you have assets, or they manufacture these disabilities, and these people end up as wards to the estate, which is very unfortunate because they end up losing everything. And then once they deplete you of your funds, they have a tendency to give the guardianship back to the family, but only after they depleted all your assets. Litigation.
Isn't that a cute game for the bar-carded people?
It sure is.
And they live in very fancy homes after they get that many guardians under them, don't they?
Yes, they do.
They drive the best cars and wear the best suits.
The best cars, the best suite, and the finest restaurants while you're living in a nursing home indigent.
Because they're eating up your estate.
Eating up your estate, taking your bank accounts. They keep you out of your house, and they go through your antiques. They take their antiques, and one of the attorneys says it's a very incestuous business because they steer the under guardianships. There's insurance, bankerage, brokerage, mortgaging, tax press, nursing homes, and all these people, even the social workers in the nursing homes, network with these esquires that do probate. These disability frauds that go on.
Wow. Wow. This sounds like a familiar story I heard up in Minnesota. I heard about this in Colorado. I didn't know it was happening in Ohio.
Should I mention Dispatch? The Dispatch series is dispatchunguarded.com. So anybody can go to that archive and pull up these articles on these people who were, the Dispatch told Geraldine Stanton, "You're lucky to be alive." Now, her best friend Kim Albert was, we believe, homeless and human trafficked into the nursing home system because basically they're after your benefits. So what they can, the attorney makes money by being your guardian, and the nursing home makes money by going after your Social Security trust fund money. So if they're able, like I said, the law firm will use a social worker, and sometimes they're not even licensed. And we said with Dr. John Randall, the unlicensed psychiatrist, there was no full disclosure of him being unlicensed. I mean, my 60B, which was the fraud action, wasn't filed until 2004. So for 25 years, nobody was making disclosure on him being unlicensed.
Now, this bar-carded person that goes on trial,
Paul Kornick.
Yeah, has he been disbarred yet?
I believe there's an action pending through the disciplinary council.
And the guy that's about to, what's his name? He's about
Kevin
to be
Crane.
sentenced in October.
Yeah, Paul Kornick will be sentenced October the 20th.
Has he been disbarred yet from the private bar card
I sure
club?
hope so. He
But
should
you
never
don't
have
know.
a license. I don't know yet. I've blown the whistle to FBI agents. I've blown the whistle to sergeants in the Franklin County Sheriff's Department. He approached the county prosecutor, and he said it was going nowhere on the investigation. So we know the county prosecutor, the judges are complicit. We don't refer to it as government anymore. We refer to it as like a corporate circus. There isn't really no government per se. These are for-profit corporations fleecing the citizens of America.
So would it be accurate to describe it as the bar-carded private club running a RICO operation, a criminal operation against we the people? And secondly, would it be accurate to say that we the people no longer have a government of, by, and for the people, regardless of party?
Regardless of the Democratic Party or the Republican Party, there is no more government. There are only for-profit corporations. We know that every one of these guardianship actions creates bonds. We know that these so-called pseudo-courts are nothing more than extortion banking centers, and that it's all about, I call it dollars for dementia. These thugocracies operate only to fleece the people, not to help the people. And when you go to blow the whistle to the Attorney General's office or to the police force, you're running them up against usually high-ranking Freemasons who also are charged with cover-ups. Now, when I went to my accountant and had the paperwork overlooked, because my mom was under guardian for 6 years, he gave me an information referral form. We sent on to the RS, and he checked 2 boxes. He checked organized crime and forged and altered documents. And I took that to law enforcement, and the FBI should say, well, this doesn't meet the nexus for RICO. And about maybe 4 to 6 weeks later, then they charged the attorney under the Ohio RICO statutes.
So who prosecuted the guy that is being sentenced this October, that former bar-carded attorney?
The Chief Economics Crimes Prosecutor for Franklin County is Jeff Blake. His supervisor would be Ron O'Brien, and the assistant county prosecutor would be Thomas Allen.
And so they actually did get him convicted.
They did get the bar member convicted.
Did he plead out, or
he pled guilty?
He pled guilty.
10 of the 11 counts, they dropped the 11th count of RICO.
So he's going to prison under RICO statutes.
No, he's not under RICO statutes. He's going under prison for theft, for falsification of paperwork. Now, it's a felony to falsificate a probe. It's also a felony, we know, to to falsify a probate document. That is a felony in the state of Ohio, when they falsify probate documents. And we know that we also want to get a taxpayer lawsuit against Dr. John Gale Randall because they were using taxpayer funds to fund the unlicensed psychiatrist who made over $200,000 for doing these evaluations from 1976 on up to 2003. And he also ran a private practice over on Zollinger Road in Upper Arlington.
Wow. So he made over $200,000, unlicensed psychologists made over $200,000 per year or over that whole span?
Over that whole span for doing these evaluations. This is taxpayer funded fraud.
Did he testify at all as to how much time he actually spent?
I
mean, doing the evaluations or any of them?
It was a dispatch article said that it was titled "Courts Relied on Unlicensed Psychiatrist," and that they just forced him. He never had a license, but they told him he could be no longer. The state medical board said you can no longer practice in the state of Ohio or be a licensed physician. So he wasn't even prosecuted. And we tried to get him prosecuted. That's when I went to Sergeant Dave Hunt of the Franklin County Sheriff's Department, and that's when he came back to me and said that Ron O'Brien declined to prosecute him because he was told by the judge, another corrupt judge, Lawrence Belskis, that he did good things for the court. So there was a good old boy system that we were running up against.
The judge had told the police officer this unlicensed psychiatrist did good things for the community?
Yes, he did. That was the judge telling the Franklin County prosecutor that.
And that was Judge who?
Judge Lawrence Belskis.
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 And is he still on the bench?
Actually, he was with Wilesboro, Burkholm, and Bringarner, and he was steering these guardianships to his friends at that law firm. One of his friends was a former judge by the name of Michael Close, and one of the individuals was a state senator who got barred from doing probate. He was State Senator Jim Hughes. He's the one that there was also a Korean War vet. They cleaned him out. His name was Miles Keith. And I actually have the lawsuit, not with me, but there was a lawsuit filed, a 9-count lawsuit, and one of them was civil conspiracy, abuse of process. It just ran the gamut. They held him in a nursing home in Bexley, and State Senator Jim Hughes was barred from doing probate because he was one of the persons that stole from him too.
So he can do other kind of lawsuits, but he can't do...
He can no longer do probate. He was barred from doing probate, but that lawsuit was successful. That lawsuit was filed by a former attorney of mine, Dennis Fennessy, and Tim Ryan of Gallagher, Gams, Prine, Talon, and Luttrell. But even when you after you ask the attorney to prosecute, the bar can lean on your attorney and threaten them, and you can then withdraw from counsel on you if they get pressure from the Bar Association, leaving you without an avenue of approach for relief.
And do you know that that's happened at least once in matters you're familiar with?
Yeah, because I've got the articles that the dementia ruined his life and lawyers ruined his life. This was a retired Korean War vet who also worked for the city of Columbus, was worth over $1 million, and he had rental properties, and by the time the litigation was all over, they kept him in the nursing home for 18 months. He was they stole over probably about $750,000 from him.
Is he suing to get anything back?
He's deceased, but his sister is a child psychologist by the name of Etta Brown out in Oakland, California. I'm very good friends with her, and they won their lawsuit, but I think the lawsuit was, they gagged order the amount of the lawsuit. It was he got about 10% of actually he was worth about $75,000 in the lawsuit. And she was told by her attorney it would be a good idea for you to go back to Oakland and not stay in Franklin County too long. Tim Ryan told her that.
And Etta Brown would be about how old?
Etta Brown is probably about 73 years old. That's Miles Keith's sister.
Interesting. Very interesting.
But this is probably going on all over the country. The probate courts are totally, not courts, the probate corporations, because these are not courts of law. They are they are prize courts, and your prize is the value of your estate, the money and property. And the longer they can keep you in probate, we call it slow walk. They slow walk you through the process in order to bleed you out and steal the value of your estate.
In your mother's case, has she recovered any of the estate value that they stole from her while they had her as a ward of the state?
We haven't recovered one penny yet. The attorney, which would be Michael O'Reilly, we wanted to go after three things. We wanted to go after, the first thing we wanted to go after would be the client security fund. Then we wanted a malpractice lawsuit against both attorneys. Now the attorney, one of the attorneys, Jay Leshner, took money to oppose the guardianship and filed a brief that this guardianship should not go forward. Then he flip-flopped on us at the last minute, did what's called accommodation settlement, applied for the guardianship. So he took money to oppose it and then applied for it all within a 3-month time span. He flip-flopped on us.
So would you tell people generally never hire an attorney?
I would say do not hire an attorney because you're going to go through a process where you cannot win. The cards are stacked against you, and all they want is the value of, they want to run the bill up as fast as they can, and they want to embezzle as much money as they can. And they call it it's not a lawful system, but they call it a legal system. But there's nothing legal with what they do. It's all smoke and mirrors.
There's nothing lawful about it either.
It's plunder and deceit, pure plunder and deceit.
Plunder and deceit by the private club, otherwise known as the Bar Association.
Exactly, which is a subsidiary of the British, BAR stands for British Accredited Registry, the American Bar Association is a subsidiary of that corporation. So all esquires are titles of nobility, and the founding fathers said if you have a title of nobility, you cannot hold office in the United States of America.
Have you ever heard of the original 13th Amendment?
Yeah, I've heard of it through my common law class, the Tona Act.
Did you know a man named Gus actually has state archives from New England with the original state archives that list the original 13th Amendment prior to 1830?
I did not know that.
It's in, and he has the book, the actual state archive, because for some reason the state sold it. Decided it was too old, antique, unneeded, and superseded. And he picked it up, I think, for $200 or $300. Which is amazing.
That is amazing. I forgot to mention that you also have to bond out these guardians. So the insurance, you have to underwrite them. So we know that the insurance company was Palmer, Miller, Nelson, and before Kevin Crane got involved, Kincaid, Randall, Crane was Palmer, Kincaid, and Randall. So the insurance companies make out like bandits, and we know that Grange was a big insurance company in Central Ohio. They were underwriting a lot of these guardians.
Interesting. Well, thank you for your testimony today. Is what you're telling me true and correct to the best of your knowledge?
Yes, it is. It's also factual, and you can be documented in my probate court case and my state case. All the information is in there, and it's online. It's available to anybody. It's public record.
And they can find that where on the web?
They can find it. They can go to the Franklin County Probate Court, and they can research it through case number 484002, which is the guardianship case, or they can research it through the state case, which was 528-087, which is still pending.
528 what?
087.
08.
It's the estate case of Clara M. Michael.
All right, very good. Thank you very much for this interview.
Thank you, William, for having me today.
Another interview here down in Ohio. I'm William Wagner, and we're here on the ground in Toledo. This is not a green screen shot. So now we're going to ask a guy named Bill, I think, what he thinks and how we can possibly rectify and take the criminals in office out of office, perhaps without a lot of bloodshed. But I'm constantly aware of the fact that one of our founding fathers said every generation you will have to shed the blood of patriots and tyrants to maintain liberty. And it's been over 150 years since we had a civil war. Here we go. William Wagner here again in Toledo, Ohio. And right behind me, in front of you, is a unique person named Bill Elwood, who spent more than 30 years studying the grand jury. So let's see if we can get enough good information that could help somebody somewhere in these 50 United States that could help fix what's killing our country. Welcome, Bill Elwood.
Thank you.
So, what's the first thing someone should know about what we call the We the People grand jury, or a common law grand jury, or is there no difference?
Well, it depends on the viewpoint that you look from. if you look from the legal perspective, there are no grand juries in the United States. There have not been any grand juries in the United States since the beginning of the Civil War in 1861. The institution that the Bar Association refers to today as the grand jury is their grand jury. It's not the grand jury under the Constitution. What we have today is the same jurisdiction operated by the same union of people, which is an international union, that was complained of in the Declaration of Independence. If you go read the Declaration of Independence, you'll find that they complained of the jurisdiction of the Crown and how they'd sent in swarms of his agents to eat out our substance. That has not changed. That jurisdiction is the very jurisdiction we're under today. And we can go into in-depth exactly what has to be done on an individual basis and who has to be involved to get back to the grand juries that were authorized under the Constitution. So, in order to understand what I'm talking about, let me read you from a court case from a currently sitting Justice of the United States Supreme Court. In the case, there's a case called the United States versus Williams.
1992 case 504 U.S. 36.
1992 case 504 U.S. 36 or 118 legal edition 2nd at 352. And Justice Scalia was writing for the majority, and he confirmed that the American grand jury is neither part of the judicial, executive, or legislative branches of government, but instead belongs to us, the people. It is in effect a fourth branch of government, governed and administered to, directly by, and on behalf of the American people, and its authority emanates from the Bill of Rights. The acts of the grand jury is consistent of the consent of the people. So what he's saying is the lawyers and the legislatures don't determine what law is in this country. The people determine what law is through their only vote that counts, and that's their vote on the grand and or petit jury. Your vote in the voting booth doesn't count at all. That's been proven over and over. They don't even count those. Okay, so the only vote we have left, and the only vote that really counts, which most people dismiss completely, is your vote in the jury box as to whether or not we're going to accept what the legislature has handed down that they want us to accept as a law. If we don't want it, the juries don't convict. It's that simple. Now, let me read you what Scalia says. And I quote, "The grand jury is mentioned in the Bill of Rights, but not in the body of the Constitution. It has not been textually assigned, therefore, to any of the branches described in the first three articles. It is a constitutional fixture in its own right. In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people. Thus, citizens have the unbridled right to impanel their own grand juries and present true bills of indictment to a court which is then required to commence a criminal proceeding. Our founding fathers succinctly thereby created a buffer the people may rely on for justice when public officials, including judges, criminally violate the law." Now, the problem we have is nobody knows this stuff because nobody reads it, because they're too busy chasing around a worthless green piece of paper they think is money. And they don't pay any attention to this. Even the prosecuting attorneys pay no attention to it. Okay, that's the problem we have. We have this jurisdiction that nobody understands. Okay, there's 4 different laws or jurisdictions that are named in the Constitution. First one is called law, L-A-W, and standalone that means the common law of the land. Then it names equity as the second jurisdiction. It names admiralty as the third jurisdiction, and it names maritime as the fourth jurisdiction. Now, one of the things that we did for years is we kept hearing from some judges, they kept saying, you guys need to find the books of the Benedictine. Not knowing, we looked for a title of a book called The Books of the Benedictine. Lo and behold, about 8 years later, we found those books in a law library that were not even cataloged. And since that time, we were able to obtain the first edition of this book, and it's called The Law of American Admiralty and Its Jurisdiction and Practice, and has the forms, etc. And this is the first edition of it. Now, the importance of this, and by the way, we had to get this out of England because it's not available anywhere in the United States.
Really?
Yes.
You had to, you went to England to get it, or sent someone to get it?
We had to buy them from England, and we had to buy a minimum of 10 at a time to get them. And we got these probably 20 years ago now. Okay. We found this after we found these, which is the 6th edition of the same book, and this was the books that we found that were uncatalogued in a law library at a major university here in Ohio.
How did you find them if they were uncatalogued?
It was a will of God, and I could go into the story to tell you about that, but that would be something for another story for a later date. But let me read you some important things out here. This is the 6th edition of this thing. And in this little book that we put together from those two things, this is the 1st and the 6th edition. The important parts that we found out of this, okay? If we go to subsection 21 of the 6th edition, it says, concurrent jurisdiction under Act of Congress, the Judiciary Act, which in 1789 established the United States courts and defined their jurisdiction as contemporaneous construction of the Constitution, and confirmed the existing right of the common law courts by providing that the United States District Court should have exclusive original cognizance of all civil cases of admiralty and maritime jurisdiction, etc., saving to suitors in all cases the right of a common law remedy where the common law is competent to give it. The saving of the common law remedies, however, has not allowed to permit the saving of remedies unknown to the common law, such as workmen's compensations remedies. Then in the next, it goes on next, subsection 22, the common law remedy saves to suitors is the right to proceed in personam against the defendant, which the remedy common law is competent to give. Now, it goes on in subsection 23, and it tells us how the state courts are supposed to function. Amazing. Subsection 23 says exclusive admiralty jurisdiction in rem. The right to proceed in rem is the distinctive remedy of the admiralty and hence administered exclusively by the United States courts in admiralty. No state court can confer jurisdiction upon its court to proceed in rem, nor could Congress give such power to a state, since it would be contrary to the constitutional grant of such power to the federal government. The Savings Clause of the Judiciary Act and of the Judicial Code does not contemplate admiralty remedies in a common law court. Its meaning is that in cases of concurrent jurisdiction in admiralty and at common law, the jurisdiction in the latter is not taken away. The remedy which state courts may administer, though it may be subject of regulation and modification by state statute, must be according to the general course of the common law. Yet today, you ask a judge about common law and they pretend that they don't know what you're talking about. I've never heard of it. Well, if that's true, they've never studied law. They've only studied administrative procedures, which is what's used in the court, which is a hodgepodge of admiralty maritime law. Okay. So we have this situation where an international union called the International Lawyers Guild, which by the way in 1950 was determined by our own Congress to be the bulwark of communism in America, and we have those documents certified out of the public record to prove that.
You have those with you?
I don't know if I've got those or not. I may have.
What year was that, 1943?
1950.
1950?
Yeah. Okay. They determined, in fact, that the International Lawyers Guild, or which the Bar Association is a member of, all bar members have been granted a title of nobility of Esquire. That term Esquire is a title of nobility that's presented under the King's precedent of the King of England, and that can be found in Blackstone's Commentaries on the Common Laws of England, which is 4 books and 2 volumes, and that was the actual law that the Pilgrims brought to this country with them, that they followed, and this country was founded under, is the common law. The Constitution itself is actually a common law document. Okay.
You're saying the Pilgrims actually brought copies of these documents with them?
Yeah, they brought the books with them.
In 1630 or
Yeah.
1638 or?
Yep.
It wasn't on
Now-
the, it wasn't on the Plymouth. I mean, it wasn't on the first ship, was it?
Now, what happened? No, is well, I don't know about the very first ships, but the books, the Common Laws of England was the only law that was known to them. They brought that with them. Now, Blackstone, William Blackstone, he took the English common law, okay, and he adapted it to the U.S. Constitution. And those books are called Blackstone's Commentaries on the Common Laws of England. And in those books, okay, there's 2 books called the Rights of Things and the Wrongs of Things. And the other books is the Rights of Persons and the Wrongs of Persons. Okay, it's the basic foundational fundamental law that this country operated under up until sometime in the 60s. All attorney lawyers that went through the school system.
When you say 60s, you mean 1860s or 1960s?
1960s. Okay, all of the law schools, the basis or foundation of their curriculum was Blackstone's. Okay, Edith Jones basically has referred to that in her statements in Harvard University in 2004 when she addressed the graduating class. One of the key statements she made then is that she made the statement that today the American jurisprudence system, or the American judiciary, is corrupted almost beyond recognition. And that was part of our opening statements to the 2004 Harvard graduating class. So we have a problem in this country. It's a gross misunderstanding by the common man, believing that these people that run what we are told are courts, which are in fact not courts at all, they're nothing more than banks. But we have been led to believe that we go there for justice. But there is no justice to be found there other than just us attorneys. Okay? So the remedy is in the Constitution itself. And the sad part about it is it's under one word. Okay?
It's under one
word.
One
word in one of the Bill of Rights uncovers an entire new judiciary system that you just heard me quote Antonin Scalia tell us about, which he quoted as being called the 4th branch of government. Okay?
Which
and that one word is called presentments. Now, if you go into Black's Law Dictionary and you study and look up the legal definition of presentments, okay, it opens up this whole common law system that follows to create what you have to follow to create the presentments. And that's where nobody knows anything about it. Not even the last Chief Justice that I know of that actually studied those things was the last Chief Justice that recently retired.
prior to Roberts?
Prior to Roberts was, now I can't remember his name, left my mind there real quick. But he, almost every one of his decisions, he quoted out Blackstone's Commentaries on the Common Laws of England as his authority for making his determination. So we've got away from the common law because we've allowed an international union that operates under the same jurisdiction complained of in the Declaration of Independence to take over our courts. Now, as you saw me read right there out of the Admiralty Law, the Law of American Admiralty, which is this book. These books, by the way, today are the authority on the American Admiralty, which is what the federal courts operate under. Okay?
So you're saying the federal courts are always acting under Admiralty?
Admiralty Maritime.
And they're always, every time they
It's
open the court doors?
exclusively their jurisdiction, meaning it was assigned specifically to the federal courts. Okay? It cannot be exercised by the state courts at all. Okay? And that the state courts are barred from having any kind of a court system with a jurisdiction that has actions in rem, meaning actions against things like ships, unless it has access through a navigable waterway to the ocean. Now, Ohio, we can have admiralty courts here because we have two navigable waterways that open to the ocean. You have Lake Erie that goes to the St. Lawrence Seaway, and you have the Ohio River that ties into the Mississippi that goes to the Gulf. So in Ohio, we're kind of in a precarious situation because under the Judicial Act of 1789 that created the federal court structures and system and defined the state courts and how they have to operate, it says unless you have that access to the ocean, you're barred from having a court with actions in rem, meaning under Admiralty Maritime Law. Now, what transpired is the Civil War broke out, which had nothing to do with slavery. It had everything to do with money and who was going to control the money in the courts. Which bank was going to control here, the Rothschilds or the Rockefellers? So the Bar Association, in the very beginning of this country, if a bar member was found, an esquire was found inside the limits of a village after dark, they were usually tarred and feathered or railroaded out of the city because they knew how corrupt they were. And we have now...
What year are you talking about?
Oh, at the very beginning, first 25 years of this country. By the way, here's the actual document that I spoke of earlier.
This is the document. The National Lawyers Guild. Oh yeah, the National Lawyers Guild. I've heard of that reference that it's all composed of communists.
Yeah. Now let me read to you. Here's their certification out of the library that we...
Yeah, read.
Let me read what it says to you here. Report on the National Lawyers Guild, legal bulwark of the Communist Party. That's what it says right there on the front page.
Yep, it certainly does. That's what it says.
Pursuant to House Resolution 5, 79th Congress, First Session, the National Lawyers Guild is the foremost legal bulwark of the Communist Party, its front organizations and controlled unions. Since its inception, it has never failed to rally to the legal defense of the Communist Party and individual members thereof, including known espionage agents. And anybody can go pull this out. It's down there. It's part of the public record. Okay. We have all kind of interesting reports like this that we've pulled out. Okay, now,
So if we have no lawful grand juries as mentioned in the Constitution and common law, and the one that the county district attorneys put together and call the grand jury, that are appointed by judges usually,
right, they're not grand juries at all.
then everybody they indicted and put through trial should be freed?
Pretty much. Now let me, and here's where I say, let me read you a really old case very few people in the world have ever even seen. Okay. It's from a really old case. It's out of the South Carolina. Let me do that. I just had it here. This case is from the Superior Court in Wilmington, North Carolina, in the May term of 1796. And it's called Cruden versus Neal.
You're right. I've never heard of Cruden versus Neal.
Okay, let me read some excerpts out here, some interesting
Okay?
tidbits from that Superior Court.
It's got my undivided attention.
When a change of government takes place from a monarchical to a republican government, the old form is dissolved. Those who lived under it and did not choose to become members of the new had a right to refuse their allegiance to it and to retire elsewhere. By being a part of the society subject to the old government, they had not entered into any engagement to become subject to any new form the majority might think proper to adopt. That majority shall prevail as a rule posterior to the formation of government and results from it. It is not a rule binding upon mankind in their natural state. There, every man is independent of all laws except those prescribed by nature. He is not bound by any institution formed by his fellow men without his consent. Okay? As we read through this decision, we find later on back here, they talk about the juries. It says, a citizen of North Carolina may forfeit his right of protection by the commission of high treason. But whether he has committed high treason or not can not otherwise be ascertained but according to the rule of the Constitution, which declares, Section 9, that no free man shall be convicted of any crime but by a unanimous verdict of a jury of good and lawful men in open court as heretofore used, and Section 12, that no free man ought to be taken, imprisoned, or deprived of his freehold, liberties, or privileges, or outlawed or exiled in any manner, destroyed or deprived of life, liberty, or property, but by the law of the land, meaning the common law. A citizen of this country, before he can be subjected to the punishment of treason or to the disabilities consequent upon it, must be convicted of a jury of his neighborhood, upon the previous accusation of a grand jury of his neighbors. Also, upon a trial before a court appointed by law for the purpose of seeing that he has every legal advantage the law entitles to him. Not every legal advantage the law entitles to the prosecutor. He is not to be deprived of his liberty or of his rights essential to his enjoyment, but by the law of the land. And what is the law of the land? Such acts of the legislature only as violate none of the rules laid down in the Constitution, such as allow the citizen the privileges there secured to him, acts inconsistent with the rights of freemen as declared in the Constitution, which take away their constitutional privileges, which in short deprive a man of his life or of the means of protecting by any application to the laws of his country for redress of wrongs without a previous trial by a jury and a conviction by them, are not laws of the land. Such are acts not authorized by the Constitution. They have no claim to the obedience or support of the citizen. As laws, they are void. Now, that's one of the highest courts that existed in this country in 1796. And they say the jury must be made up of what they call peers, but here we find out what the definition of a peer is, and we find out that the peers are the man's neighbors from his neighborhood.
That's what it says. It definitely does. I've never seen
It says he
that.
has upon the previous accusation of a grand jury of his neighbors.
So
Now, today, where do they get these people they call grand jurors or petit jurors, the 12-man jury, which now think, gee, it's only like 7 or 8 of them when it's supposed to be 12. They go out and get unknowns out of the street off of the voting list, people that have registered to vote, that have accepted the franchise of a foreign jurisdiction to be allowed to, instead of cast a ballot, click a Chad, okay? and they take those people that are unknowns and they give you not a trial by jury, because a trial by jury would have to be a trial of your neighbors that know you, that know how you operate, that know whether you're a crook, whether you're a drunk, whether you're a drug addict, or whether you're a good, honest Christian man, or whether you're a Muslim or you're from a foreign country. They know everything about you. That's why you're supposed to be tried by them. But instead today they have what they classify as a jury trial. And a jury trial is not the same thing as a trial by jury. A jury trial is a trial by unknowns that know nothing about you. Okay? They have no clue who you are or how you normally operate, what is consistent or inconsistent about your character, which is contrary to what the Founding Fathers created for us. Now,
Wow.
under...
That strikes me as really an important issue. That strikes me as an important issue because I know I got called for federal jury duty in Los Angeles, 150 miles from where I live.
Right.
And there's no way I could have been a neighbor to anybody in Los Angeles who was a defendant from Los Angeles. And yet they called me, paid me well to come and sit in a room waiting to be called. And I was not a neighbor to any of those cases.
Right.
That's a really interesting point you bring up in that case.
Now, let me throw a little more of a tidbit in here from another really, really old book that we found, happened to be run across inside one of these old law libraries. This is called A Treatise Upon Some of the General Principles of the Law, whether of a legal or of an equitable nature, including relations and applications to actions and defenses in general, whether in courts of common law or courts of equity. Now, if you talk to any bar association people, they say, well, there's no such thing as a common law court. Well, there may not be today, but there used to be. And I've given you two incidences of proof of that. One directly out of the act that created the federal courts, okay, and one out of this old book. And this is an 1877 book.
Yeah.
Okay. Volume 1. But here's the interesting thing about this. Title 1, Chapter 1, Title 1 of Contracts and Torts, of Rights of Person and of Property in general. Section 1, some general considerations. Every person has an interest in the laws and the remedies which exist for the protection of person and of property. The rights of natural persons are either absolute and as such relate to life, limb, liberty, health, and reputation, or they are relative and such as pertain to the relations of husband and wife, parents and child, guardian, ward, and master and servant, and the like in instances. There are also rights of the artificial persons, such as corporations. And that's where we have the problem today. Corporations are considered and put on the same level as you and me as live individual persons. Okay? Now, the problem what we have, though, is a corporation is a person. But you and I are not. We're people. If you go back and look in the legal old historical use of the term person, a person originally was a mask worn by an actor to help project his voice on the stage. And it depicted either his character that he was portraying or himself, but the person was not the man that was wearing the mask. The person is the mask. And what the corporate governments have done today...
Sorry. Say that last part again. Whoop. Rolling again. Go ahead.
Okay, today the corporations, the corporate courts, which are really banks creating bonds, have placed all of us and placed a personage on over our existence.
You mean in all cap titles, when they title you in all capitals and call you to their bank to extract money from you?
Exactly.
Force you to make forced deposits into their bank.
Exactly. We have all the history on that as well to show, even the English history that shows there's nowhere in any English curriculum any authority for the capitalization of your name they're not grand juries at all.
Then everybody they indicted and put through trial should be freed?
Pretty much. Now let me, and here's where I say, let me read you a really old case very few people in the world have ever even seen. Okay. It's from a really old case. It's out of the South Carolina, in Wilmington, North Carolina, in the May term of 1796. And it's called Cruden versus Neal.
You're right. I've never heard of Cruden versus Neal.
Okay, let me read some excerpts out here, some interesting
Okay?
tidbits from that superior court.
It's got my undivided attention.
When a change of government takes place from a monarchical to a republican government, the old form is dissolved. Those who lived under it and did not choose to become members of the new had a right to refuse their allegiance to it and to retire elsewhere. By being a part of the society subject to the old government, they had not entered into any engagement to become subject to any new form the majority might think proper to adopt. That majority shall prevail as a rule posterior to the formation of government and results from it. It is not a rule binding upon mankind in their natural state. There, every man is independent of all laws except those prescribed by nature. He is not bound by any institution formed by his fellow men without his consent. Okay? As we read through this decision, we find later on back here, they talk about the juries. It says, a citizen of North Carolina may forfeit his right of protection by the commission of high treason. But whether he has committed high treason or not can not otherwise be ascertained but according to the rule of the Constitution, which declares, Section 9, that no free man shall be convicted of any crime but by a unanimous verdict of a jury of good and lawful men in open court as heretofore used, and Section 12, that no free man ought to be taken, imprisoned, or deprived of his freehold, liberties, or privileges, or outlawed or exiled in any manner, destroyed or deprived of life, liberty, or property, but by the law of the land, meaning the common law. A citizen of this country, before he can be subjected to the punishment of treason or to the disabilities consequent upon it, must be convicted of a jury of his neighborhood, upon the previous accusation of a grand jury of his neighbors. Also, upon a trial before a court appointed by law for the purpose of seeing that he has every legal advantage the law entitles to him. Not every legal advantage the law entitles to the prosecutor. He is not to be deprived of his liberty or of his rights essential to his enjoyment, but by the law of the land. And what is the law of the land? Such acts of the legislature only as violate none of the rules laid down in the Constitution, such as allow the citizen the privileges there secured to him, acts inconsistent with the rights of freemen as declared in the Constitution, which take away their constitutional privileges, which in short deprive a man of his life or of the means of protecting by any application to the laws of his country for redress of wrongs without a previous trial by a jury and a conviction by them, are not laws of the land. Such are acts not authorized by the Constitution. They have no claim to the obedience or support of the citizen as laws. They are void. Now, that's one of the highest courts that existed in this country in 1796. And they say the jury must be made up of what they call peers, but here we find out what the definition of a peer is, and we find out that the peers are the man's neighbors from his neighborhood.
That's what it says. It definitely does. I've never seen
It says he
that.
has upon the previous accusation of a grand jury of his neighbors.
So
Now,
when-
today, where do they get these people they call grand jurors or petit jurors, the 12-man jury, which now think, gee, it's only like 7 or 8 of them when it's supposed to be 12. They go out and get unknowns out of the street off of the voting list, people that have registered to vote, that have accepted the franchise of a foreign jurisdiction to be allowed to, instead of cast a ballot, click a Chad okay? And they take those people that are unknowns and they give you not a trial by jury, because a trial by jury would have to be a trial of your neighbors that know you, that know how you operate, that know whether you're a crook, whether you're a drunk, whether you're a drug addict, or whether you're a good, honest Christian man, or whether you're a Muslim or you're from a foreign country. They know everything about you. That's why you're supposed to be tried by them. But instead today they have what they classify as a jury trial. And a jury trial is not the same thing as a trial by jury. A jury trial is a trial by unknowns that know nothing about you. Okay? They have no clue who you are or how you normally operate, what is consistent or inconsistent about your character, which is contrary to what the Founding Fathers created for us. Now,
Wow. That strikes me as really an important issue. That strikes me as an important issue, because I know I got called for federal jury duty in Los Angeles, 150 miles from where I live.
Right.
And there's no way I could have been a neighbor to anybody in Los Angeles who was a defendant from Los Angeles. And yet they called me, paid me well to come and sit in a room waiting to be called. And I was not a neighbor to any of those cases.
right.
That's a really interesting point you bring up in that case.
Now, let me throw a little more of a tidbit in here from another really, really old book that we found, happened to be run across inside one of these old law libraries. This is called A Treatise Upon Some of the General Principles of the Law, whether of a legal or of an equitable nature, including relations and applications to actions and defenses in general, whether in courts of common law or courts of equity. Now, if you talk to any bar association people, they say, well, there's no such thing as a common law court. Well, there may not be today, but there used to be. And I've given you two incidences of proof of that. One directly out of the act that created the federal courts, okay, and one out of this old book. And this is an 1877 book.
Yeah.
Okay. Volume 1. But here's the interesting thing about this. Title 1, Chapter 1, Title 1 of Contracts and Torts, of Rights of Person and of Property in general. Section 1, some general considerations. Every person has an interest in the laws and the remedies which exist for the protection of person and of property. The rights of natural persons are either absolute and as such relate to life, limb, liberty, health, and reputation, or they are relative and such as pertain to the relations of husband and wife, parents and child, guardian, ward, and master and servant, and the like in instances. There are also rights of the artificial persons, such as corporations. And that's where we have the problem today. Corporations are considered and put on the same level as you and me as live individual persons. Okay. Now, the problem what we have, though, is a corporation is a person. You and I are not. We're people. If you go back and look in the legal old historical use of the term person, a person originally was a mask worn by an actor to help project his voice on the stage. And it depicted either his character that he was portraying or himself, but the person was not the man that was wearing the mask. The person is the mask. And what the corporate governments have done today...
Sorry. Say that last part again. Whoop. Rolling again. Go ahead.
Okay, today the corporations, the corporate courts, which are really banks creating bonds, have placed all of us and placed a personage on over our existence.
You mean in all cap titles, when they title you in all capitals and call you to their bank to extract money from you?
Exactly.
Force you to make forced deposits into their bank.
Exactly. We have all the history on that as well to show, even the English history that shows there's nowhere in any English curriculum that has any authority for the capitalization of your name other than the law specifically states that the name of any corporation must be in all Roman numerals. And I can show you that right out of the statutes. Okay. Let me get back to this, what the purpose of it for. It says right there, the rights of, it says every person has the interest in the laws and the remedies which exist for the protection of person and of property. If we go to the next page, it may be said generally that all civil actions are founded upon some act or some omission in regard to private rights or duties in relation to a person or property. So the law itself, okay, the purpose of the law itself is to protect you and me, our rights, and our rights to private property. That's the whole of the law. Now, when I say law, I mean common law. But when you say law to an attorney, it has a completely different connotation. It has nothing to do with you or me as living beings. It has everything to do with commerce and things.
So would you recommend people learn the common law and never hire an attorney?
Attorneys have their places, don't get me wrong. Attorney's job is to create controversy in commerce so he can get paid because he has nothing else that's sellable. He has no practical skills. That's why they become attorneys. Okay? Today we have a corporate welfare system we call the judiciary. And we have the problem we have is we have all of these attorneys that come out of these schools that have never studied law. They never study law at all. The only thing they're taught in school is procedure. Well, procedure can be learned out of a book. Okay?
Well, in fact, some Supreme Court appointees back in the 1790s did exactly that. They had no law school background, and they read a law book for 2 weeks and took their seat on the Supreme Court.
Exactly.
So procedure can be learned.
Right.
So what I'm finding is across the country is that people who are most successful in fighting these banks they call courts have given up on attorneys, stopped wasting money hiring attorneys, and they've started to learn both the common law and the lawyers' procedural laws.
Correct. Now, the courts that operate today operate under administrative law because they're all administrators. And we can find that in this book, which is the Civil Judicial Procedures and Rules of the Federal Courts. And in this book, this happens to be the 1993 edition. It's all dog-eared and tore up because this is my research. What I want to show you here is that we have been schmoozed into believing that these attorneys are learned in the law. Okay? Everybody thinks if you got a problem with the law, you got to run to an attorney. If we look in the book, we find out it's quite the opposite. So this is Title 28 of the United States Code. We're going to go to the section under the Department of Justice, Chapter 31, the Attorney General, and we're going to start over here at subsection 501 under the Executive Department that says the Department of Justice is an executive department of the United States at the seat of the government. The Attorney General in 503 says the President shall appoint by and with the advice and consent of the Senate an Attorney General in the United States, and the Attorney General is the head of the Department of Justice. We go to 504A down here. It says Associate Attorney General. The President may appoint by and with the advice and consent of the Senate an Associate Attorney General. And then it goes down here and says subsection 505 Solicitor General. The President shall appoint in the Department of Justice by and with the advice and consent of the Senate a Solicitor General learned in the law to assist the Attorney General in the performance of his duties. Now, if you read that, you would come to the conclusion that all of these attorneys are learned in the law, wouldn't you?
It gives that impression.
Okay. That is until you turn the next page. We look over here in the notes section, and we find up here it says, the words learned in the law are omitted as unnecessary. Such a requirement is not made of the Attorney General, United States attorneys, or United States judges.
Wow.
Bingo. So if they're not learned in the law, where are they learned in?
Collecting
They're
money.
learned in Admiralty Maritime, which is banking. It's the relations between merchants and banks, and merchants and merchants, and merchants and ship owners, because all, even in this year, 2015, over 90% of all commerce is still carried out on the high seas, on ships that are controlled by the admiral. That's why it's called Admiralty law. Okay, so the Admiralty maritime jurisdiction that was assigned to the federal courts goes hand in hand. It's all deals in commerce. Now, they couldn't bilk us if they looked at us as living beings. Okay, so they have to put a mask on us, a personage, okay, and then they address that a personage on their ship inside the building. And that's what that bar is in the courtroom. That courtroom bar opening represents the railing of the ship. That's why they want you to come into the courtroom, because the minute you cross the bar, you just walk down to the ship where Admiralty maritime jurisdiction takes place.
Even in state courts?
Even in state courts. It's all about, we don't have any constitutional jurisdiction. We have the jurisdiction of the Bar Association, and it's global, and it controls everything in your life, okay? Let's look at the reality of it. Any decision made at any level, from the township level all the way up to the highest levels, and I use the term loosely, government, at the federal level, there's not one determination or decision that's not ultimately made or authorized by a bar member. All of it is authorized by a bar member. And if it's not authorized by a bar member, it doesn't happen. I've even sat in township meetings where the bulk of the township that lived in that township was present in the meeting, and they took a vote on what they were going to pass, an ordinance dealing with railroad ties on the side of a road, a little turn-off place, and what they were going to do with it. And they cast, the township commissioners cast their vote after the township presence was there and cast their vote. And after it was all over, said and done, the head commissioner said, well, we can't authorize this decision at this point until we run it by the prosecuting attorney. So here's the people of the township voted, the county commissioners voted, the township people and the commissioners voted synchronicity. They voted the same way to remove these big railroad ties, but they couldn't authorize the removal until they authorized it with their prosecuting attorney. Which tells me that, why do we waste all the time with all these township commissions and county commissions and all that stuff? Why don't we just go to the prosecuting attorney and let him tell us what to do? Because the rest of it's a waste of time, because ultimately he makes the final decision anyway. So that's the problem that we have in this country. We've been duped into believing that the judiciary is something different than what the king had prior to the Revolutionary War, and we find out that if you do the study and the research, which I can go on for days and show you this stuff, we literally have tens of thousands of pages that we've got and pulled them out of the law libraries and had them authenticated.
So when the King or Queen of England and Prince William was over here, taking off my hat for you people, was over here and they referred to us as the colonies, they really weren't far wrong, were they?
No, we were the colonies. We started out, and here's the biggest...
But we still are colonies then, aren't we? Because...
Yeah, pretty much. We've never gotten out from under the colonies. If you really want to know the history of how it really laid out...
So those brave men that died at Lexington Bridge and all the way shooting the British back to Washington, they pretty much died for nothing.
Pretty much, yeah.
Wow. I mean, that's...
And all the people in the Civil War pretty much died for nothing. They died for the banks. All of the people that died in World War I, all the people that died in World War II, the Korean War, Vietnam, and all the other skirmishes that we've had around the globe, none of those people died for this country. They all died for the banks.
To make the banks rich.
Yeah, because the banks made profit on it. If you go back and do your research, you'd find that the same banks funded both sides of the Civil War. Okay, they just did it through different people. Okay, same thing with World War I, World War II, Vietnam. It's atrocious how the American people have been lied to and deceived on purpose for profit. Now, if you don't believe what I'm saying, and I'd suggest that nobody believe I'm saying. I suggest you go out and prove me wrong, and you go dig up and do your own research. But one of the things that will help real easy is take the name of any court that you think is a court of law in your state. Take the name of that court and then go to Dun and Bradstreet and run a check on a corporation. You'll find that every one of these courts has a DUNS number, meaning they're all corporations for profit. So what's happened is we've thought we elected presidents, which we didn't. The presidents were appointed by the Electoral College. The popular vote doesn't mean anything. These presidents are nothing but puppets. The presidents institute all of these laws and regulations, sign them into law, whether it's initiated in the executive or whether it's initiated in the legislative, and every one of these laws is set up to profit the for-profit corporations. And if you've been paying any attention, there's nothing been passed, and I'm 65 years old. I've not seen anything since I started paying attention to this when I was 10, because I was forced to when I was in school. Okay. And so I kept that up my whole life. There's nothing that's ever changed. There's nothing that's been done in the acts of the legislatures there to profit the people at all. It's all there to profit the politicians, who 98% of them are esquires, and to profit all the big corporations. And people think the police and all these alphabet agencies like the FBI and the CIA are all there to protect us. They're not. They're there to protect the government agencies. Okay. So we've been duped.
We've been duped. So this brings me to my question that I came here for. How do we, the people, form a lawful de jure common law grand jury that can make lawful presentments or indictments of the criminals in office who are operating under color of law?
Okay. It's not anything that can be, I can explain it briefly, but to understand it completely, you have to take a very in-depth look at it, okay? But it takes, several things have to be put in place. First of all, the people have to do this, and you don't get paid for it. You have to volunteer to do it. The second thing that has to happen is you have to be in the proper standing to be able to do it. So you can't be a corporate slave and be a free man. And all of the old records that we've pulled out, if you go clear back to the very beginning, and of course we're going to have to adjust that a little bit nowadays because different laws have been passed, but originally the judges in the county, the only person in a county that could be a judge was classified as a free man in freehold. And what that meant was that the guy owned 350 acres of land or more that he paid with in gold and silver coin. That was a free man in freehold. Now, that's an impossibility today because there's been nobody in this country since the Nixon era that has ever even had the ability to pay for anything, period.
In gold and silver.
In anything, because in 1913, the Federal Reserve Act was passed, and if you read all of the documents and laws that related to the Federal Reserve Act, especially House Joint Resolution 192, and where it was codified into law, which is 42 Stat 42 or 48 Stat 48 112, I think it is. I have to look that up again. But anyway, it was codified into the statutes. Debt can only be discharged in this country pursuant to those laws because they took away our ability to pay because they took away the gold and silver coin. So we operate on promises to pay, and that's what a Federal Reserve note is. And it says, if you look at the very top line on a dollar bill, it says Federal Reserve note. Now, note is a promise to pay. So a free man in freehold today is virtually an impossibility because he had no money to buy the 350 acres with. Okay, so if we look at historical, what can we do to find somebody that could be classified as somebody as a freeholder? Well, in order to do that, we'd have to go back to the 7th Amendment to the Constitution. And to paraphrase real quick what the 7th Amendment says is that any controversy where the value exceeds $20, the right to a common law remedy shall be held inviolate, meaning they can't take it away.
They intended 20 gold dollars.
Silver or gold.
Silver or gold. And
right. Okay, so this is,
We don't have that anymore.
well, you can still buy the silver dollars today, but I'm not sure if it's real, even pure silver anymore. I haven't looked at any of them lately. But in 1930s, there was a big meetings held overseas, and all the governors of the United States were kind of colluded together with the Bar Association to declare bankruptcy through a treaty. And the ensuing result of that was the withdrawal of the gold under Roosevelt in 33 through 35 and all the laws that were passed under that. Those dollars after the bankruptcy and the Emergency Relief Act under Roosevelt are bankrupt dollars. So any dollar that's minted after basically 1933 is a bankrupt dollar. Any dollars that were minted prior to 1933, like this one, are non-bankrupt dollars. Okay, and this is a 1922, I believe it is. Here's a 1922 silver dollar. So that's a non-bankrupt dollar. So the closest thing that I could possibly do in today's environment, since we don't have any money, is to collect 21 or more of these pre-1933 silver dollars. And if I hold those in my possession, then theoretically I could be classified in today's vernacular as a free man, in freehold, because I have 21 of these, which exceeds the value of a controversy talked about in the 7th Amendment. Okay, so let's look at the grand jury members themselves. First of all, today we're all enveloped with this personage that's been placed on us by the for-profit corporations posing as government, be it a township government, a county government, a state government, or a federal government. They're all for-profit corporations that pose as government, and every single one of them has a DUNS number under Dun & Bradstreet as a for-profit corporation. You can go look those up for yourself. Okay? The problem that we have is people don't understand that that personage that's placed upon us changes our status and character in the community. In order to set in judgment of somebody, the first requirement, which we looked at earlier, is you have to be learned in the law. So you have to have some semblance and some knowledge of, just as an example, jurisdiction. What is jurisdiction? Nobody knows. Even the attorneys don't understand jurisdiction. But in every instance, jurisdiction has 7 elements. And the law itself says that if you're charged with a crime in a Supreme Court case called Higgins versus Levine, the Supreme Court says your first duty is to challenge the jurisdiction of the court. Now, had they been able to tell the truth, they would have said your first duty is to challenge the standing of the prosecutor to initiate the jurisdiction of the court. Okay? And if you do that and you understand and you study that, you'll find that none of these prosecutors have standing. And you also find that none of the people in this country, unless there's someone like myself that have become learned in law, have the 21 silver dollars in their possession. They don't qualify. They don't have the standing to be a grand juror. Okay? So the first thing they have to do is they have to get rid of that personhood. They have to get rid of that, and they have to stand on their own. Now, all of that's in the history, and it all can be looked up, okay, and it all can be read, and we're putting the classes and all that stuff together to teach people how to do this. But the first thing that has to happen is they have to be in the proper standing to be able to be chosen and be elected to the grand jury position, because they have to be elected to that position by the county. And the person that holds that election, it has to be a special election that's held by the sheriff of the county, because he's the highest law enforcement of the county. He's elected to that position by the county people that live in the county, and he is the ministerial officer of the independent common law grand and petit juries. And we find that in Blackstone's commentaries on the common laws of England.
You said even the prosecutors don't have jurisdictional standing,
No.
but they have status, don't they? They're elected as prosecutors, so wouldn't they have the status and then the jurisdiction?
Well, let me ask you something. If there were no ballots cast and no ballots counted to put him in the prosecutorial position, was he elected? Because if you go back to in the historical archives, you'll find out that if you're going to vote for somebody in a particular office, you're required to cast a ballot. There probably hasn't been a ballot cast in this country since 1935. There hasn't been a ballot cast in this country for sure since they went to the electronic voting booths. Okay. So for your answer is most of these people have never been elected to those positions. It was a quasi assignment to dupe the American people into believing that they had elected somebody.
So then the prosecutors don't have jurisdiction and we can't form grand juries?
No, we can't form grand juries because they're not operating for government at all. They're a foreign jurisdiction.
So to get a grand jury, we need people that have 21 pre-bankruptcy silver dollars
In their possession,
in their possession
are learned in the law.
and learned in the law.
They have a sheriff
They have
that is elected in their county who will hold a special election to elect the qualified members in the county that qualify to be elected as grand jurors, and they are elected by the people of the county, and that's where they get their authority. They're elected officials elected by the people that live in the county where they're going to hold that grand jury.
So the grand jury, whether it's 17 or 25 people, have to be elected.
Yeah. So
And the sheriff has-
proper grand jury in this country is to be made up of 25 men and women plus 2 alternates. So a total of 27 have to be voted into the county. And the
And that
sheriff,
has to be a special election.
the sheriff holds a special election that he puts in a newspaper, a legal newspaper, advertises for 3 weeks before the election that on this day he's going to hold this election to elect these grand juries, and here's the list of the people in the county that are qualified to meet that position.
Well, that's the answer. Thank you very much, Bill Elwood. It took us, I think, over an hour to get to that answer. I understand what you're saying.
And I've just given you a very small background.
Yeah, just a small background. But I think it's more likely the militia will show up like they did at Bundy's Ranch and stop the tyranny of the federal courts before a grand jury will ever come together.
The militia is the enforcement arm of those grand juries.
Right,
And they are supposed to operate under the sheriff.
but they didn't have a grand jury at Bundy Ranch.
No,
The
they
militia
didn't have
just
grand-
showed up.
I applaud that. Absolutely applaud that for happening. But we have an option, and we're at a point right now. You can do it and do it right the way the archives say it's supposed to be done, and the case law is there that supports this, okay? Or we can do it wrong and end up right back at the same place we're at today.
Okay. Well, there you have it. Thank you very much, Bill Elwood, for that. I'm William Wagner in Toledo. I hope you learned something. I hope you do your own research and validate for yourself. I'm William Wagner. Going to put my hat on and head back to California.